Okay, I think we've got most of our participants in the room. So Mike, I think we can go ahead and get started.
Good. Well, good afternoon, everybody, and welcome to the Kane Shannon Weiler webinar. My name is Michael Weiler. I am the senior member of the Employment and Labor Group at Kane Shannon Weiler. Now, senior simply means that I got my vaccination a lot earlier than Chris did. With me is my colleague and my friend, Chris Drinoff. Chris is the head of our Employment and Labor Group. I'm also proud to announce that Chris has recently been made a partner of Kane Shannon Weiler, which is helpful for our group, and we're really proud of him. So we're really glad that you could take an hour to be with us today. We appreciate your interest in our webinar. So I was thinking, where were you in March 2020? Do you remember what you were doing? Do you remember you getting ready for your spring break? I remember we were looking to do our first Zoom webinar. I had to learn all of that stuff. I do remember the stock market nosediving by 35% by March 31st, 2020. And I do remember a number of businesses, clients of ours, scrambling to figure out what was going on. So everyone struggled coping with COVID. There's no question about that. And that continued through the fall and into the spring. We had all the golf courses in Ontario closed by Doug Ford. So that's changing. But 1 year since the pandemic was announced has some really good news. The Globe and Mail said this morning, the stock market, the TSX, is up 80% since then. So some things are certainly going well. But the key thing, and the thing we'll talk about today, is the miracle of vaccines. And it truly is a miracle. Anybody that's studied this will understand that normally they think vaccines will take 5 to 10 years. They still don't have one for AIDS. So this really is a miracle. But with every miracle comes some challenges. And that's what we'll talk about today. As I like to remind people, including myself, we may be at the edges of the forest, but we're not out of the woods yet. And that's what we're going to talk about today. So it's easy to say, look, follow the science. But that's easier said than done. It's a very windy road. Look at the rules on masks. Anthony Fauci was saying, well, don't wear masks. We don't think they're important. Well, that was simply because they didn't have enough masks. But clearly the science is that you have to wear masks. And variants and all of these things are changing. What Chris and I will provide you with is a template on a voluntary vaccination policy. Chris will review for you. But if you want to look at something like a mandatory policy that has a lot of consequences in it, you need to discuss that with your professional advisors to find out what should be included for your workplace. So our goal today is to identify the issues and the questions that might arise as you look at the possibility of bringing in such a program. It's important to bear in mind that different workplaces will have different considerations. There's the COVID-related legislation. A couple of points I want to make. If you're federally regulated, you're in a different set of rules than provincially regulated employer. For example, the Canada Labour Code deals with unjust dismissal provisions, which now are basically the same as having a union. So that's not what we're going to talk about. We're going to talk about BC. So for example, some people in attendance today have operations out west. Some of them have operations in Ontario as well as BC. We're only going to talk about BC, but bear that in mind, the rules may be different. The other thing is, are you unionized, or are you non-union, or are you a combination? Those will impact on your vaccination policy, what you can do and shouldn't do. So you have to look at that. But let's be clear, as I say, unless you're 103 years old, you were not alive when this last worldwide pandemic was there. So we're sailing into uncharted waters still, and we're doing our best to respond to it. The policies that you put in place today will likely be around for quite a while, well into the future. First dose, second dose, COVID-21. So it's important to look at it and not just short term, but long term. Quickly going through the rules and format, lawyers love rules. First of all, ask questions. Hit the Q&A button if you have questions. We've had many people provide questions in advance. I hope that Chris and I have been able to answer the vast majority of them in our presentation. Any that we don't answer, we will follow up with an email with the question and the answer for everybody. So don't worry if your question didn't get asked and answered. We'll deal with that after. We can't provide legal advice. It's sort of like having the second best hand in poker. Sounds good, but you're in trouble because you forgot to look at a particular fact. But at least you're asking the questions and you're looking at these areas so you can get advice and deal with it on a fairly quick mandate. Lawyers love interesting questions, as all of you know. You know, when I say it's an interesting question, you run for your checkbook. So we're going to have some interesting questions today. Hopefully we can give you some insight and avoid the problem. Also, Anna reminds me that if you've got a technical problem, you can email Anna. Also, we'll be providing a video and material from this after. So if we go a little bit longer and you miss some of it, the video will be there. So I'm going to turn it over to my friend, Chris, and he'll talk about workplace vaccination policies.
Thanks very much, Mike. That's great stuff. And thank you to everyone for taking some time out of your day and joining us. It's a real pleasure to have you here. When I think back to the state of things 1 year ago in May of 2020, it was absolutely chaotic at that time. And the major questions coming in from our clients and businesses centered around, can I lay off my employees? Are there going to be constructive dismissals? How do I get a variance with employment standards? And navigating the various government benefits such as the CEWS and the CERB. So fortunately, the CEWS became so complicated that the lawyers were able to hand it over to the accountants. And I didn't have to look at any more spreadsheets. But 1 year later, we're still talking about COVID, but in a much different way and in a much more positive and hopeful lens. As Mike said, the miracle of finding a vaccine so quickly has created a new set of legal issues to deal with and talk about. And the primary thing coming out of that is vaccination policies, and that's what I'm going to focus on today. So as of this morning, the province of British Columbia had administered about 3.3 million doses of the vaccine, which represents just over 60% of the total population and 68% of the eligible population over 12 years old in BC. In addition to this, about 200,000 British Columbians have received a second dose. If you look at Canada, nationally, there have been about 25 million doses administered, which represents about 60% of the population having its first dose. So despite these encouraging numbers, there have been a number of polls consistently showing that about 10% of the Canadian population currently says they do not plan to get the vaccine. So it's certainly important to discuss the issues of vaccination policies at the workplace, because it's going to be a relevant issue for a number of months, if not longer. So I think that the $1 million question that we're getting from our clients is, can I require my employees to get vaccinated? And the best I can do here is give the classic but frustrating lawyer's answer. It depends. I think for various constitutional and policy reasons that are beyond the scope of today's talk, neither the provincial or the federal government have chosen to make vaccinations mandatory for everyone by law. So there's no law that we can point to say, employees, you must be vaccinated in order to come to work. However, in my view, the government has taken some actions, less significant or extreme actions, that signals that it expects employers to encourage and promote their employees to be vaccinated. And I think this is supported by the fact that the BC government and other provincial governments have amended employment standards legislation to require employers to give up to 3 hours of paid leave in order for employees to be vaccinated. And Mike will discuss this in detail a little bit later in the presentation. And so by shifting this burden to employers, the government is clearly sending a strong message that all employees should be vaccinated and that the consideration of safety in the workplace is paramount and may trump other rights such as individual privacy and human rights, which again, Mike will discuss. So obviously, as an employer, you can't physically force an employee to get vaccinated. But what you can do is tell employees or create a policy that your workforce must be vaccinated in order to keep their jobs, i.e. you make it a condition of continued employment. And this can be done by introducing a workplace policy requiring vaccination as a condition of continued employment, and or setting rules around those who choose not to be vaccinated. And I think, as Mike said, you need to seek advice on your particular workplace and the different considerations if you're going to go in the direction of a mandatory policy. And the big question you need to ask yourself is, how strong do you want to be on your rules, and what risks are there for implementing them? And I want to go through a number of kind of underlying considerations that hopefully will help you inform yourselves when you consider these things. First and foremost, all employers have a statutory duty under the Workers' Compensation Act to provide a safe workplace for all employees and all workers on site, even if they're not your employees. And part of this duty is having a system in place to keep your workers safe from COVID-19 transmission. And in my view, this includes having a COVID-19 safety plan, which is required, but also I think it now includes the obligation to have a proper vaccination policy or set of rules around vaccinations. And we've put some data up on the slides showing the effectiveness of the various vaccines. And you can see there that particularly the Pfizer and Moderna vaccines, which are the most common in BC, have been shown to be 94 and 95% effective in preventing symptomatic infections for those with no prior infection. So the science is pretty clear that the more workers you can get vaccinated, the safer your workplace is going to be. And an employer can face fairly significant consequences if they breach WorkSafe BC rules and regulations. And that includes orders against them, administrative penalties and fines, and various other measures, even criminal sanctions if there were to be gross negligence resulting in a COVID outbreak. So this is now compounded by the extraordinary powers that have been given to the Medical Health Office to shut down a workplace entirely for 10 days without warning, with no recourse or right to appeal, if the medical health officer believes that there's been transmission of even one case at the workplace. And I'll talk a little bit more about this later in the workplace closures part of the presentation. So all of these things are very serious potential legal and financial consequences to consider. On the non-legal side of things, you also want to consider the morale at your workplace. Your employees and your customers are going to feel safer in a fully vaccinated workplace. Employees that feel safe are likely to be happier and more productive, and customers and clients that feel safer are going to be more willing to come into your workplace and do business with you and use your services. So there's lots of good reasons to think seriously about a strong vaccination policy. And when we talk about mandatory policies, we don't have a lot of precedent, but we can look to the healthcare sector for some guidance. And there certainly is a precedent in the healthcare sector for mandatory vaccination. British Columbia has had an influenza prevention policy in place since 2012, which requires all healthcare workers to either be vaccinated against influenza every season or wear a mask when they're giving patient care. And this policy has been quite controversial. It's been challenged numerous times by various unions. And initially, a healthcare worker could actually be disciplined for breaching the policy. They could be suspended without pay or face other disciplines. But after a series of grievances, the disciplinary aspect of this policy has been removed. But the mandatory aspect of the policy has been upheld. And arbitrators and courts around the province and throughout Canada have determined that in healthcare and long-term care settings, these mandatory types of policies are reasonable. And they come to those conclusions based on the scientific evidence that the risks of exposure in those particular workplaces and the effectiveness of the vaccine in preventing those risks makes sense. So I think there would be similar considerations in an analysis of COVID-19. Obviously, there's a higher mortality rate, and I think the vaccines are even more effective with COVID. But these arguments have yet to be fully considered, particularly outside of the healthcare sector, where the risk of exposure is not as high. And so we really are, as Mike said, in uncharted waters when it comes to giving you any sort of certainty on whether such a policy would be forcible. So for those outside of the healthcare sector, mandating that all your employees receive the vaccine may be more difficult to justify, and it could invite legal challenges and could create morale issues for your employees. And if you ask yourself what could possibly go wrong, I read this morning that in Texas, a group of 117 workers have filed a lawsuit against the employer's mandate requiring all staff to get COVID-19 vaccinations. And in that case, the employees are arguing that the compulsory immunization requirement violates the Nuremberg Code, which was a set of standards designed after World War II to prevent experimentation on human subjects without their consent. So it's it's an extreme example, and we ain't in the southern United States. But anytime people are told they must do something, there's bound to be resistance, people that disagree, and this may be detrimental to your workplace culture. So certainly there are, even in British Columbia, people that still have reservations about the vaccine, are concerned about side effects, concerned about the long-term effects. And these are not just anti-vaxxers I'm talking about. And there are also people that believe in the science and the effectiveness of the vaccine, but object to an employer mandating something that violates their individual right to bodily autonomy, which has been held to be a fundamental human right. So for those reasons, employers should also consider the less controversial approach of having a voluntary policy instead of a mandatory one. And this type of approach would focus more on encouragement, peer pressure, education, and could be implemented in a manner that hopefully still achieves the primary goal of getting the vast majority, if not all, your employees vaccinated and keeping everyone safe and happy. So we spent some time thinking about the best format for what a voluntary policy should look like. And as Mike said, at the conclusion of the webinar, we will share a template that you can work with. It's important to know that this is just a template with suggested language, and you need to review it carefully with your professional advisor and make sure it fits within your organization's culture and brand. And again, whether you're federal or provincial, whether you're union or non-union, will be relevant considerations. So this is very much just a template. So Anna's brought the template up on the screen here, and I'm just going to review some of the key provisions. And if people have questions about implementing them, we can certainly be available for that in the days and weeks to come. So it starts out with a clear statement of the purpose of the policy, and we've made reference there to the Workers' Compensation Act, which is that foundational duty to keep a safe workplace. In this particular policy, because it's voluntary, there's confirmation that the policy is voluntary, but the employees are strongly encouraged to get vaccinated. And again, it hopefully will play on the idea of encouragement, and the more people that get vaccinated, the easier it is for the other employees to do it as well. One suggestion we've put in there is to host a Q&A with a medical professional or a public health official. Those types of people are readily available to come into the workplace or do a Zoom to answer any questions the employees might have. And again, that's the aim of that, is to kind of create a culture of education and let the employees inform themselves so they can make a proper consensual decision as opposed to being told. There's an information section as well, which again goes to kind of the education piece with some objective science-based statements and to dispel hopefully some common vaccination myths. So those statements might include that vaccines will not make you sick with COVID, that they've been shown to be highly effective, like some of the data we've shown earlier, that getting vaccinated protects not only the employee, but the people around them, that they're an important tool to help stop the pandemic and help the business stay open. And the low likelihood of a serious reaction to the vaccine is outweighed by the benefits to the employee and their loved ones. So the utilitarian appeal. So there's some links there as well to some government resources so people can fact check. And a very important statement that we recommend you put in there, that all other COVID prevention measures provided for in your existing safety plan will remain in place, regardless of vaccination. So you need to maintain all of your other social distancing and other measures until further notice from the government. There's a section on vaccine administrations. Now, I myself got my jab on the weekend, but employees are now entitled to request up to 3 hours of paid leave. And I expect that many employees are wanting to take advantage of that. So we need to provide for that in the policy, and Mike will talk a bit more about 3 hours paid leave that's now available under the Employment Standards Act. If the employees schedule the vaccination outside of work hours, they're not entitled to be paid unless you decide to pay them. And we've included some language in there for addressing a situation where there is an adverse reaction and you need to engage additional sick time under your sick policy or other policies. We've also included a section on incentives, and this is where you can really get creative as an employer. Certainly incentives are optional, but definitely a good way to get a higher percentage of people vaccinated in a shorter period of time. Many large Canadian organizations are doing incentive programs, including Manulife, CP Rail, and a number of smaller companies. The template language includes various options, such as giving a one-time bonus. I saw some companies are giving a $100 bonus or $300 bonus. Some additional time paid off. I think CP Rail is giving people the entire day off plus another day if they get vaccinated. Or you can do a gift card and maybe even partner with a local business or something like that to do a gift card program. Another option that I've seen and heard of is a lottery. Having everyone that's been vaccinated put their card in and give a prize or prizes to the winners. And one thing to remember is when you are rolling out your vaccination program, be sure to specify when the incentive is going to be payable. Is it payable on the first shot, or do you need to have both? So I'll just quickly finish up here. So the next section deals with the record of vaccination. A common question I've been getting is whether you can ask employees if they've been vaccinated and whether you can require proof. This will not be an issue for the majority of people. Most people are happy to tell you they've been vaccinated, but technically speaking, the vaccination status is a confidential medical piece of information. But that being said, I think the right to employees' privacy is not an absolute one. And the test for disclosure of this type of medical information is based on principles of reasonableness and proportionality. And we've seen that balance shifting since the pandemic started with things like temperature checks. So I think given the importance of safety and the employer's safety obligations, it is appropriate for employers to ask the employee to disclose vaccination status. And that's consistent with some of the guidance we've seen from privacy offices. And that would apply to current and potential employees as well. Some other key sections are a policy modification section. You want to keep it flexible for any changes you want to make down the road, a non-retaliation statement, a statement about human rights, and it ends with an acknowledgement that you want to keep on record. So, like I said, have a look through the policy when we send it over to you, and if you have any questions, let us know. I'm going to turn it back over to Mike now to talk about human rights.
Great, thanks, Chris. Good job. Okay, problem employees and human rights. First of all, as Chris says, the majority, won't present problems. In fact, my group generally, we keep telling everybody, hey, I just got my first shot. I mean, it's not something that people in the group I'm involved in are wanting to hide. we all want to get back to playing hockey. So there's a different sense, but that doesn't take into account that some people may have very legitimate reasons for not wanting to be vaccinated. Generally, in a non-union setting, provincial employers can terminate employees that refuse to get vaccinated or follow your COVID policy. Now, we'll talk about the human rights issues for protected groups. If you have an enforceable employment contract, it may well be that you can, for those that do not want to follow the vaccination policy, if it's mandatory, you may have to pay them severance pay or provide them notice. And it depends on your contract. It may be as minimal as the Employment Standards Act or something much broader. In any event, so that's something you want to look at when you're looking at someone who won't get vaccinated, won't follow the policy. It might still be just cause, and we'll talk about that a bit. But that's a questionable one. Chris mentioned that there may be human rights issues, not just in terms of employees that are currently affected by your policy, but in the hiring stage. And I think that's a good opportunity as any employer to say, look, be proud of the fact you've got a mandatory vaccination policy and you need people to follow it. I think that's a bona fide occupational requirement, and so that refusing somebody who hasn't been vaccinated, or at least holding them off and hiring until they're vaccinated, may well be justified. It's essential that, of course, you consider your human rights code obligations. There are exemptions and accommodations, as all of you know, in the implementation of worksite policies. So if someone has a protected ground, for example, religion, or have a disability, they have a right to be accommodated in certain circumstances. I should also note that Chris mentioned you can use the carrot to get people, the incentives to get people to get vaccinated. Well, again, those could create some human rights issues too, right? That somebody says, I can't get vaccinated because of a disability. That may create some issues, I don't know. So with respect to imposing a mandatory policy, you may see objections like this. We've given some here: an allergy to a vaccine or an ingredient in it. So far as we've seen some allergic reactions, but they're extremely rare. Autoimmune or other pre-existing conditions which prevent them from being safely receive the vaccine. And again, much will depend on the science. People I know that do have autoimmune conditions have taken the vaccination. So again, it's a question, follow the science. Objections based on religious beliefs, such as faith-based healing. So the duty to accommodate, as we all know from listening to us, is not unlimited, but you have to do it to the point where it reaches an undue hardship. So in the context of one employee with a legitimate medical or religious exemption, this may simply involve considering having them work remotely, temporarily reassigning duties, or maintaining existing mask and screening measures. These types of situations, again, in our view, will hopefully be rare, but where the employee refuses to follow the policy because of personal preferences or personal concerns about the safety or the effectiveness, those concerns don't provide protection under the Human Rights Code. You have to have a disability or a protected ground. You have to be negatively affected, and you have to show that that there's a connection. So we'll talk about a couple of cases where that didn't, where the people complaining could not satisfy those conditions. Absent a compelling reason that links the employee's concern to a protected ground, a general objection or a mere preference is not protected, and therefore does not displace the policy. So given the devastation of COVID-19, my personal view is that the Human Rights Tribunal, as well as the courts, can be much more sympathetic to employers who in good faith try to implement one of these policies in their workplace. I mean, to me, the primary concern is safety. Safety for your employees, safety for you, safety for your business. Your customers are far more likely to patronize your operation, I think, if your business if they know that everybody's vaccinated, or at least the vast majority. I want to remind people of some dicta of our Supreme Court of Canada when they're dealing with human rights cases. They're not all against employers. There's some reasonable comments, and this is one of them in the leading case of Hydro-Quebec, where the Supreme Court of Canada cut back on what they meant by you must accommodate to the point of undue hardship where it's impossible to find an accommodation. Wilson J. addressed the factors that may be considered when assigning an employer's duty to accommodate an employee to the point of undue hardship. Among the relevant factors are the financial cost of the possible method of accommodation, the relative interchangeability of the workforce and facilities, the prospect of substantial interference with the rights of other employees. The various factors are not entrenched, except to the extent that they're expressly covered by the statute. This is the important point. Such consideration should be applied with common sense and flexibility in the context of the factual situation presented in each case. May I remind you, we are in a pandemic. We are not out of it yet. So there are a couple of recent cases of the Human Rights Tribunal, and I know we're sort of on the clock, as they say in golf. So I'll just direct them to you, but both of them dealt, interestingly enough, with the Human Rights Tribunal issuing a decision at the screening stage, which is really unusual. Normally they look at it, if it seems to be generally okay, they send it to the employer, yada, yada, yada. This one, they said, no, we're not even going to send it to the employer. We're going to punt these two cases. One of them had to do with an employee who went to a store, was told you must wear a mask by the security officer, and was not allowed in. She filed a complaint. The Human Rights Tribunal, on a screening decision, said, no, you don't have a disability. You haven't provided us with evidence that you have a disability, and it is connected to your inability to access the store. The second case was a religion one, which is really a slippery slope in human rights, as people know. But even there, where the religion claims were made, they didn't bear out, and so the claims were punted. Both of these were masking cases. And so I think it gives me the sense the Human Rights Tribunal are going to be very, very practical about these situations and what factors an employer must take into account. Several factors are going to be taken into account. I think the fact that the government, even though they haven't made it mandatory by statute, they've said, look, we really are telling you everything but mandatory. You got to get vaccinated. Employers now have to pay for people to get vaccinated. So to me, the quid pro quo has to be, you got a right to have a vaccination policy. Otherwise, it doesn't make sense that we're forced to pay for employees to get vaccinated. And as Chris has noted, we've had cases where the workplaces, including car dealerships, et cetera, have been shut down 10 days, 14 days immediately because of COVID in the workplace. These are serious things. So I think you can push the envelope. I think it's better basically to ask for permission than forgiveness. Sorry, to ask for forgiveness instead of permission in many of these cases, that you have to be practical and move quickly. So those are some of the takeaways. I'm going to turn it over now to Chris to deal with the expedited workplace closures and that I referenced here. Chris, do you want to take it away?
Great, thanks, Mike. So I'm going to say a few quick words on these workplace closure orders that have come into effect in April. So since April 8th, 2021, the BC government has instilled in itself the extraordinary power to close down an entire workplace for a minimum of 10 days. And a closure order can be issued if a medical health officer reasonably believes that one or more persons has been infected with COVID-19 while in a workplace, and that is necessary for the workplace or part of the workplace to stop operating to prevent further transmission of infection. So in reading that language, it's important to know that the test requires the employee to have been infected while actually in the workplace. The transmission has to have occurred between employees at the workplace. It doesn't apply if the employee got COVID outside of the work. It's really designed to deal with workplace transmission. And so between April 12th and May 28th, in a 6-week period, WorkSafe has issued around 74 of these closure orders in the Fraser Health region alone. And you can go online and see the different types of businesses that have been closed, but it's all types of businesses, like Mike said, from car dealerships to gyms to restaurants to processing facilities, you name it. So WorkSafe BC prevention officers, they've been delegated the power to serve these orders and to work with the employer on their COVID safety plans after the closure. But the orders themselves are actually made under the Public Health Act. And so it's the health authorities, the medical health officers that are making these decisions and calling the shots and dealing with the administration. The most extraordinary thing in my view is that there is actually no recourse or appeal from a closure order. In the normal course, under the Public Health Act, a business would have a right of review under the statute, but these rights have been specifically suspended based on the emergency powers sections of the Public Health Act that have been invoked and enforced since the state of emergency. So the fact that you can't really do anything about it is all the more reason to be vigilant with your safety plans and proactive with your vaccination policies, as Mike has said. Practically speaking, I can give you a few tips from experience on these closure orders. Generally, what triggers a closure order investigation are one or more employees reporting a positive COVID result in the workplace. And once that information is known, environmental health officer will start an investigation and will probably contact the employer to ask some questions. So if you find yourself in a situation where you're getting a call from the health office, the most important piece of advice I can give you is to seek professional advice right away. In our experience, it may be possible to intervene at the investigation stage and provide information to the medical health officer before they actually decide to issue the order. And if you can point to some facts or evidence to show that the transmission didn't occur in the workplace, it may be possible for you to get out of the order. And I'm aware of an example where the employer was able to show convincingly that the employee in question had actually been working remotely and hadn't attended the workplace, and so the transmission couldn't have occurred. And upon learning of that information, the health officer decided not to issue the order when they were going to issue it prior to knowing that. So if you are issued an order, our experience is that notwithstanding the absence of formal recourse or review, the medical health officer is willing to listen to the employer and perhaps make some concessions to allow some people to go into the workplace to do things like payroll or essential administration or dealing with urgent customer needs. So it is still worth seeking some advice because there may be some flexibility during that 10-day closure period. Second thing that I'll touch on briefly that we thought everybody should know about is the rapid testing program in British Columbia. The program is called the COVID-19 Rapid Point of Care Screening Program, and it allows employers to apply for and receive rapid testing kits from the government called point of care test kits. Basically, these are devices that can be used as a screening tool for COVID-19 for employees that don't have symptoms, and it's a nasal test, and the benefits are that it's rapid, provides results within 15 or 20 minutes. Of course, it's not as accurate as the PCR test, which is kind of the gold standard, so you cannot conclusively confirm or rule out COVID, but it can certainly give you a more reliable indication than the basic screening or self-assessment tools or temperature checks, and certainly can give you and your employees a better feeling of security. So if you are interested in accessing these test kits, there's some information on the slide there. You can contact the government team at the email there, and they'll do an intake assessment. The review process is based on the rapid testing strategy, which is about a 5-page slide you can download there on the link. And basically, in order to be eligible, you need to show that the settings or activities of your business are associated with an increased risk of transmission of COVID-19 due to high contact between workers or the public. So in some of the examples, they talk about long-term care, congregate living facilities, food processing plants, on-site work camps, those types of settings. And high contact is defined as having close interactions between large numbers of employees or between employees and large numbers of the general public. So I think there's a large number of these kits available. And if you are a larger organization, or if you have employees that are dealing with the public regularly, I think it is probably worth looking into and applying. Originally, there was a requirement that a healthcare professional administer the tests, but this has since been relaxed. And there are some requirements for training and reporting of positive cases, but it's certainly something worth looking into. We posted an article there from the Financial Post, which has a great a number of additional information there. Okay. So I think that's all I have on rapid testing. I'll turn it back to Mike to talk about sick leave.
Good, thanks, Chris. We're back on time. Yes, I think those the whole concept of rapid testing is of interest to me. I think it's going to be tied into vaccination passports and all of that stuff. But it's all just another tool in the toolbox to try to prevent the spread of this deadly disease. So we'll now talk about three amendments to the Employment Standards Act that we've generally mentioned, but a little bit more detail on. As you know, the BC government stepped in fairly quickly, both through the Employment Standards Act and through WorkSafe, to provide procedures and rules on how you as employers and businesses can deal with COVID. The Provincial Health Authority, as you know, can take decisive action under the state of emergency declaration, as Chris has pointed out, but also the recent circuit breaker orders. I mean, think if you're a restaurant and you've ordered everything for that long weekend, and then they tell you on the whatever it was, the Thursday, you're shut down. I mean, these are extraordinary times, but those are extraordinary powers. The Employment Standards Act, and again, this is a provincial statute that will deal with BC. Check the Canada Labour Code if you're governed by that. Check Ontario's Employment Standards Act and Infectious Disease Act and all of those. So unfortunately, you have to go jurisdiction to jurisdiction. But our Employment Standards Act has been amended in many ways to respond to it. One of the key ways that many of you will know is that they made it much easier to obtain a variance of the termination severance provisions of the Employment Standards Act. So a layoff that previously 13 weeks within 20 has now been extended, and you can extend it through a variance. So that avoids the immediate impact of severance pay provisions. Now, at some point, those chickens are going to come home to roost, but certainly now you have breathing space because they took action to modify a statute that wasn't really ready to deal with pandemics. So what I'll do is look at a couple of, or three of the provisions. Again, all I can do in this thing is alert you to the critical areas. I think you have to get into the details, and we've had some questions that deal with that. So the first one, as many of you will know, quite quickly in March of 2020, I mean, that's within 7 days of the declaration of pandemic, they introduced 5212, which was to provide for an unpaid leave of absence in certain circumstances. So if you were diagnosed with COVID, you were acting in accordance with the advice from a healthcare professional, if you were in quarantine or self-isolation, or interestingly enough, if the employer had directed the employee not to work because of concern about creating infection in the workplace, the employee is entitled, in other words, if you've got an employee who's providing care to an eligible person, or the employee is outside the jurisdiction and can't return due to restrictions. So those were the general thing, but they were all unpaid leave of absence. So the amendment provided for you could get proof of entitlement to the leave, but you couldn't ask for a medical note from a medical practitioner, a nurse practitioner, or a registered nurse. So there were restrictions on it. You almost had to rely on the good faith. The section also provided for 3 days of unpaid leave, generally, not COVID related, for illness or injury. And I want to point out that these leave provisions, that this one and the other ones I'll talk about, are all subject to sections 54 and 56, which deal with the rights of employees that are on these leaves. So for example, mat leave, you got to give them a job when they come back, you can't discriminate, etc. Also, and I didn't note it here, but section 126.4 says that you, the employer, have the onus, it's a reverse onus of proving that your decision with respect to terminating or discipline or whatever had nothing to do with a legitimate leave. So there are restrictions on there. You got to be careful when you're in this area. Okay, so that's the first one. Then the second one was brought in to deal with vaccinations. Section 52.1.3 was made law on April 27th, 2021 to provide that every employee is entitled to up to 3 hours paid leave in order to be vaccinated for COVID-19. So it's not a flu vaccination 3-hour gimme, it's for COVID. And that is a restriction just in and of itself. And it's up to 3 hours. I think that means consecutive hours. I don't see how else it could be. And to me, if their appointment is at 4 o'clock and they leave at 3 and claim 3 hours when they would be finished work at 4, they don't get it. Now, who's going to micromanage these things? I don't know, but it's just something to note. It doesn't seem to be that they have to give you advance notice, which I find kind of odd. But anyways, the paid leave, as I noted, is retroactive, but only to April 19th, 2021. Now, there are provisions for how you pay wages. As I say, every employee is entitled to it. So a casual, a full-time, a part-timer, new hires, they're all entitled to it. There's no restriction on how long they're employed or what their status is. But that's taken care of in terms of where the rubber hits the road. How much do you have to pay? And what they've done is incorporate, many of you that have had to look at statutory holiday pay for new employees or casuals, et cetera, they have provisions where you go back effectively an average over the last 30 days what their hourly rate or rate of pay is, excluding overtime. So there is protection there so that your part-time employee is going to get a lot less than your full-time employee for the 3 hours they go to get the vaccination. But try to read that. It's like reading the Income Tax Act. I have trouble following it, but it's there in terms of the formula. Employers are entitled to request reasonably sufficient proof of the employee is entitled to the leave, which may include, in my view, proof of vaccination for COVID. Now, that may be a dispute whether you can ask. I think you can ask. Again, rather to ask for forgiveness than permission, in my humble opinion. But that doesn't make sense that you can't ask them specifically for evidence. But and the reason I say that is that the statute goes on to say you can't request that they provide a note from a medical practitioner or a nurse practitioner or registered nurse, so that when they express that exclusion, I think they intended you could ask for other things. Remember, they're asking for a leave of absence to get vaccinated, so you're entitled to proof of same. Now, this section will stay in place. It relates only to COVID, but they can be removed by order in council, so it can be taken out quickly. It doesn't have to go back to the legislature. And then the third one is a combo. It includes a 3-day paid leave and a open-ended, as many days as the government decides you'll be paying for down the road. Let's deal with the first one. Effective May 20th, 2021, Bill 13 was given royal assent, and that means it was effective. And what it did was it provided for 3 days paid sick leave for employees affected by COVID, but in certain circumstances. And you'll recall in the 2020 COVID leave that I just mentioned, I listed a whole bunch of things. Well, the only one that they get a 3-day paid leave are the first 3, that they have COVID and that they're under direction, they're under quarantine or self-isolation. And the other one's interesting, if the employer sends home due to fear of exposure in the workplace. It's only those 3 that are covered. So taking care of, if you're a caretaker, et cetera, aren't covered by this. So it's important to know that. You only get one kick at the cat, one 3-day leave. It's not retroactive, which is interesting. Some of the questions we had were, is it retroactive? The answer is no. Well, it's retroactive now to May 20th, 2021. It's effective only till December 31st, 2021. It dies. That's the sunset clause. And you can see from the NDP's point of view, this ain't all that expensive because we're getting into summertime. A lot of people vaccinated, by then. So they're not expecting a lot of people, I think, to get in it. If you look at Hansard, they go on and on and on. The Liberals hammering about how much is this going to cost, et cetera, et cetera. So that was obviously an issue. So it may affect you in a different way. I don't know. Again, you may ask for reasonably sufficient proof of eligibility, but again, no doctor's certificate. So there's a formula, same formula, which provides there. And now here's the tricky thing. If you don't have a sick leave policy and you're non-union, you can seek reimbursement for the government up to $200 a day. Anything over that, you got to pay it. So if you have, it means that if you have a sick leave policy with your non-union people, but it's exhausted or they haven't qualified, they still get the 3 days. This statute trumps whatever you have in your policy. So you can seek reimbursement from WCB. I tried to see if there'd been more information on that. That information will be provided by WCB on June 15th. So stay tuned and look at all the rules there. In the union setting, and I won't get into the details, it gets far more complicated. And that's because of Section 3 of the Employment Standards Act that say if your collective agreement provides for a benefit that meet or exceeds the statute, then your collective agreement governs. If it doesn't meet or exceed, then the statute gets incorporated. Have a nice day trying to figure that out with your unionized employees, but it's a separate set of rules. And it doesn't replace these unpaid leave provisions, right? So the first one I mentioned still continues in existence as an unpaid leave. This is not intended to cover it. So here we go, paid sick leave 2022, version number 2. Again, this is not just a COVID leave, which is important to know. They put it in the section 49.1, which deals with just generally leave, sick leaves for personal illness or injury. And it's effective in 2022, but there's no details. The paid leave will be effective only for people that have been there for 90 days of consecutive employment. And what it says is, we'll tell you in 2022 how many days it is. So the reason for that was twofold. Number one is the NDP have been complaining that the feds are supposed to be doing this. Well, they're wrong. Sick leave is a provincial jurisdiction, and now they're stepping up to the plate. Secondly, they still want to see what the feds are going to do with EI and the rest of it so that they don't overkill. And thirdly, they want to see how's the economy. Telling employers that, by the way, you now have sick leave policies of X days may be devastating to a lot of businesses starting out. So they did what they did, for example, with the labor code. They said, well, we're going to have consultation, and that's what they're going to do. So stay tuned, folks. As soon as we know, you will know, but that's an important thing to keep an eye on. Now I'm getting well, pretty close. We're almost on the hook. So I'm going to go through a couple of cases that I think will have some relevance both to the vaccination policies, which is the key discussion here, but some of the other somewhat related issues to COVID as we come out of it, right, as we get to the edge of the forest. First of all, this case is often cited, the Barclay and Mohawk Council of Assiniboia. Now, this was a case under the Canada Labour Code, unjust dismissal. So again, it was similar considerations to a union setting. And if they find there's a violation, they can reinstate, for example. So many of the indicia of a union setting are covered by the Canada Labour Code. So the adjudicator, this is a case of a refusal to take a flu vaccination as required by the employer's directive that all staff and employees must receive a flu vaccination. Now, Chris has mentioned on that in terms of the statute. Again, all of this is a bit of a mix and a match as to what the current rules are. But I thought that the quote was important. The adjudicator said, they had a just cause to fire you. You're out the door. There's no doubt, they say, in the present instance, on the basis of the evidence which was adduced, i.e. follow the evidence, the science, that the resident's health was involved and that risks were serious. There was on the part of the council, the employer, a legitimate interest, which was the resident's health and well-being. It affected the employment relationship itself. The council was justified to rely on its community medical health officer. Its resolution to impose a vaccination policy was not unreasonable. The other requisites had been met. I'm satisfied that the complainant did not quit her job, but was terminated and terminated with cause. Such cause was not that she was incompetent or that the conduct was improper. She was and still is highly recommended. The only reason for her dismissal is that she did not comply with the resolution asking that she receives influenza vaccination. So one can see that those type of arguments will potentially be made. The next one is a recent one. Out of Ontario. On arbitration, the employee called into work saying he had symptoms that were consistent with COVID and was told, well, look, don't report to work until you hear back from the, this is a big company, until you hear back from our resident nurse. The griever attended work his next shift because he never heard back from the nurse. Without a COVID test, didn't have clearance. He claimed he had no symptoms. But in fact, as it turned out down the road when they investigated, he did have a runny nose. And we all know that that was arguably a symptom itself. He was sent home and subsequently terminated. The arbitrator upheld the discharge, finding that the grievor had in fact deliberately tried to circumvent the employer's policies, and by attending work and not being forthright about his symptoms, he had placed his fellow workers at risk. Here, health and safety considerations in the context of the pandemic were clear and were key. And you can see how this now 3-day paid leave will even give greater support, I think, for an employer that takes definitive action for employees who are reckless and not following policy on these things. As Chris mentioned, regardless of your vaccination policy, keep all of your workplace safety policies, social distancing, masking, all those things should be maintained, not just when we're on the edge, but when we're out of the woods. The last case is one that just came up a couple of days ago. Chris alerted me to it, where we've often wondered, you know, you're getting these CERB payments, and the law has always been in wrongful dismissal in other cases. You don't get to deduct EI. Who understands that? But in any event, CERB, in this BC case, they said no. The employer is entitled to deduct the CERB payments received by the employee. So $1,400 or $14,000 was deducted. And I make this point because, as I say, we have people who on this call have operations in Ontario. They distinguish the Ontario case that had been relied upon. So again, it just shows you, in my view, the courts are being much more sensitive to the fact that COVID is creating serious problems for employers, and maybe the tide is changing a bit. So maybe employers get a bit more sympathy in front of the courts, in front of the human rights, in front of WorkSafe, et cetera. So summary and takeaways. Mandatory vaccination policies should be carefully considered before introducing them into your workplace. Why do you need them? Why do they work for you? How do you want to do it? Such policies shouldn't replace your current safety policies. At the heart of the policies is safety for your employers, for you, for your customers, and for your business. I think Chris mentioned this, and I want to emphasize it again. I think selling it is really important. We have a longstanding client of mine who, when he started up in the summer of 2020, big operation, he spent an hour, videotaped it, presenting why they were going to do what they were going to do, and let's work together as a team. And it's very effective. And so that may include, for example, bringing in some experts, just so people feel comfortable. They don't just feel this is the employer putting in policies that don't make sense. Recognize and minimize the risk in implementing your policy, but be up to date on everything that's changing. I mean, read our blogs, read whatever we get in the newspaper. The medical information, government legislation is changing by the minute. And so you have to be ahead of the curve to avoid problems. And also, I always throw this in, anytime you make changes in your workplace, just be aware that unions may be sitting there thinking, well, if it's not well received, we'll have a reason to get in there and protect you. But at the end of the day, we're all in this together. And I think that's what the purpose of a vaccination policy will support. So now we can go to questions. although it's 1 o'clock. That's pretty good timing. I think what we'll do is, for those that want to stay on, we will continue for a few minutes if that works, Anna and Chris. But bear in mind, if you have to go, no problem. This will be recorded, and so you can, anything we say, you can use against us by referring to the video. So who's going to fire any questions?
Okay, yeah, why don't we deal with a couple of questions that have come in. Someone's asked, will the templates be available? Yes, we're going to send a follow-up email to everybody with the slides and the template and a guidance document. Somebody has asked, the employee was working 9-hour days each day last week, had his vaccination scheduled for near the end of his typical hours for the day. He requested the missed overtime pay as part of the 3-hour vaccination leave. Mike, do you want to speak to that?
Okay, I'm not sure I understand the facts, but that never holds me back. I think if, okay, as I say, it says up to 3 hours, right? So I'm not sure if what they're saying is he was near the end of his shift and he went and got, on his way home, he went and got vaccinated. That puts him outside the circle, right?
Yeah, and I think the employee is looking to be paid at the overtime rate for the time that he's getting the shot. And I think the statute's clear that you don't account for overtime when determining the
when you're adding the when you're adding the wages for the 3 hours. But right. I don't think, and I hadn't even thought about this, it's up to 3 hours leave from when you're supposed to be working. So if you on Saturday pop by the thing and say, well, here's a bill for 3 hours, because you don't get it. Again, I have to go back and look. I just hadn't thought about that. But again, if he's claiming overtime, he's not scheduled, is he? It's not scheduled work. So I would think he's disentitled to it completely. And you can see why. If he gets his full 8 hours of pay, right, applying the formula, he doesn't get any more money. And that's because he's not missing time from work to get vaccinated. Make sense?
Okay. Another question here. If we already provide 3 sick days, do we need to provide 3 additional days if they have not yet used their annual allotment? I would say no.
Yeah, I mean, my sense is it's not an add-on unless they don't have the sick leave. I mean, if you've got 3 days sick leave, I think you can say you can use those. But again, it's a little unclear in the statute. And remember, if you're non-union and you're seeking reimbursement, we still have to figure out how WorkSafe is going to figure out what you get reimbursed for. And my sense is that if you have a sick leave policy, they're saying, look, that's already in place. Why would we reimburse you for something, right, that somebody is assessing? If they, I guess the question could be, the employee says, well, look, I want to keep those 3 days for a regular sickness. My sense of it is, and I have to go back and look at it, to be honest, more carefully, but my sense is no. It's if you've got a sick leave policy that covers it, that should cover it.
Yeah, I think that's consistent with kind of the aim of the Employment Standards Act, which is to kind of set the minimum. And if you're already meeting that as an employer with your existing policies, like Mike says, it's not an add-on.
Yeah, good point.
Yeah.
I had one question that had been sent in earlier. I think we answered, but it was important because, are all employees who are casual or casual working a temporary line without benefits eligible for paid sick leave? And my answer is yes. When they come into 2022, that won't be the case because it's a 90-day provision. But also, I think it's all covered by how you work out the wages. So if somebody just started a week ago as a part-timer, they're going to get less than a full-time person.
Right. Somebody's asked, why do we care if the employee vaccinates or not? They're only putting their own selves at risk if everyone else is vaccinated.
Well, again, I'll let Chris answer this because I think he is far more up to speed on the science. But this is where I say you got to follow the science. And my sense of it is that, first of all, if everybody in your workplace is vaccinated, just think about it. There's a 5% risk that one of those people may not be fully protected. Although even the evidence is that 100% of the people will be some protection, but just not fully protected. So just the odds are with you to avoid any type of outbreak, right? But if you've got 100 employees and they're all vaccinated, the risk of them transmitting is limited, as I understand the science. But again, that is going to be required much more analysis. And I think that's one of the reasons, Chris, that they're not coming out with a statutory mandate that you must be vaccinated, because they're a little bit leery about the science on this, especially with, can you mix AstraZeneca with Pfizer for the second dose and yada, yada, yada. But I think if you look at the flu influenza thing, situation in an old folks home, there's not much doubt that it reduces the risk, and it's really just a matter of risk management.
Yeah, I agree. I think, and you're also as an employer, you have an obligation to protect all of the workers, including those that maybe can't be vaccinated for health reasons. And so if someone's coming to work choosing not to be vaccinated, you're allowing them to work, you're putting other employees at risk who simply weren't able to get the vaccine for legitimate reasons. I think you also want to consider risk to customers, and not just your other workers. Okay. Someone's asked, is there anything an employer can do if employees are hesitant on getting the vaccine? I understand we can't pressure them, but is the voluntary policy the best way to go about the situation?
Yeah, well, Chris has done a good review, and I think that template, that voluntary template, is excellent. I think if you read it and go through, again, you can lead a horse to water, you can't make him drink, and that is always going to be the problem in these things. But I think that persuasion is by far the better route here. There's going to be a lot of peer pressure. I mean, as I say, I haven't had anybody in my circle say, how stupid to get a vaccination. It doesn't do any good. I haven't had that. Just the opposite. We all want to get back on the ice end of June. So we're all looking at it from a different perspective. But I think each case will have to be looked at. And I think your better thing is, if you have a mandatory policy, do everything you can. If it's only a couple of people that are having trouble, deal with them. Chris?
Yeah. A couple questions about proof of vaccination. So someone's asked, can we ask our employees if they have been vaccinated yet? If yes, ask for some sort of proof. My view was that you can ask, and I think the regular privacy rules need to be respected in terms of collecting that sort of personal information. So you want to make sure that there's only a limited number of people or one person that's has access to that information, that it's stored in a safe place, and that you comply with the Personal Information Protection Act. So I think when you're looking at your policies, you want to consider, how do you collect that information? Are you satisfied with just asking someone and taking their word for it? Do you want to see their immunization card? Do you want a doctor's note? How far do you want to go in terms of collecting that information? I think are some of the important questions there.
Yeah, it depends, of course. If somebody's applying for a 3-hour paid leave, you have a right. Well, the whole essence of it is they've said, I want a paid leave to go get vaccinated. So, that cat's out of the bag. The question is, as I pointed out, you can ask for reasonable proof of vaccination, but not, for some reason, you can't ask for a doctor's note. I don't know why that's in there, but anyways.
Yeah. This goes to the accommodation. Somebody seeking accommodation. Can we demand a doctor's note if a worker states a medical condition precludes them from being vaccinated?
I think you can. I mean, I think that's a lot of people say, and in one of these cases that I mentioned, that I've put in there, the person sort of said, well, look, why does the security guard have a right to know whether or not I'm wearing a mask, or I have a condition, or what the nature of my condition is? In the other case, the person was denied access to the workplace. And again, the same thing. What right do you have to do it? Well, if you're going to file a complaint at the Human Rights Tribunal, then yeah, the employer has a right to know what you are saying you have, because you must prove you have a disability. You must prove that you've been negatively affected, and you must prove that there's a causal connection between your disability and the negative impact. So that is kind of, again, that's how it's dealt with in the human rights setting.
Okay, well, why don't we cut it off there, and we'll go through all of the questions that have been asked and make sure that we get back to people, or post a Q&A to make sure everyone's question has been addressed. Okay, so thanks everybody for joining. That was wonderful to have you with us, and we'll send an email out post seminar here with all of the slides and everything. And as always, feel free to reach out to either Mike or myself. So thanks again, everybody, and have a wonderful afternoon.